My lord, my lady, I appear for the appellant with Mr. Lowe and Mr. Laing, instructed by KPMG. My learned friends Mr. Beale and Mr. Rattan, instructed by Gowlings, appear on behalf of the respondent, who I'm going to call OFWAT, like everyone does, with Mr. Lowenthal also on the skeleton. We've agreed a timetable, subject to your blessing. I will have until 3 o'clock today. Mr. Beale will have until 12:15 tomorrow, and we'll finish by 1. You should have a core.
Well, let me help. We won't sit after 4:15 today. We'll see how we go. And of course, it's useful to have a timetable to start with, but we'll see where it takes us.
Great,
that was helpful.
You should have a core and supplementary hearing bundle. Apologies for the omissions of the grounds which have been inserted in 14A. You should have authorities bundles. I don't know which of you have gone electric like Bob Dylan and which of you are still on acoustic bundles, but my divide at tab 21. If yours divide at different points, let me know and I'll try and get the volume numbers in, and then you should have skeletons for the both of us. Now, as you know, this case is all about the regime of performance-related pay for water companies, a regime governed by a series of performance-related metrics called outcome delivery incentives, or ODIs, that operate on the back of matched performance commitments, or PCs. The better the water company does under the ODIs over performance, the more that it's entitled to charge its customers under the statutory regime for charging schemes in the next annual charging period. Similarly, poor or underperformance may culminate in what are in effect rebates in the next charging period. ODIs and PCs come in pairs, and they're set by reference to a fairly wide number of topics. For instance, leakages, average consumption per customer, the numbers of severe drought restrictions, customer measures of satisfaction or experience, CMEX in the jargon, environmental performance, and so forth. And each performance commitment has a metric, like the number and duration of leaks or the number of pollution episodes, and then a formula for the ODI calculation. Effectively, you plug the numbers from the performance commitment into the expected level of performance, and then there's a pounds per unit calculation to set the upwards or downwards adjustments. And as you know, the particular ODIs at play here are supply interruptions, or SIs. That's what I'll be referring to, not statutory instruments for once. And the operation of the exclusions about which we're arguing, the ensuing PC and ODI, are in truth mathematical formulae, and they're treated as such in the relevant condition B12. When we get to it, you'll see that very clearly. So the one for supply interruptions entails a calculation based on the number or duration of the various supply interruptions, and then deductions up and down from the expected level of performance. Now, of course, the data to police or populate these formulae is generated and quality assured, and then generally independently ordered by the water companies. That's the norm. The norm is that the water companies submit their data, and OFWAT can then effectively audit and judge whether it agrees, but otherwise the data will be used to make the relevant calculations. Some forms of data for some PCs, even where relating to matters potentially outside the formulae, have to be separately reported because they may be interesting in their own right, and OFWAT may wish to evaluate it for itself. But for the typical PC, absent an audit or evaluation, these schemes, the data used to populate them, are largely self-administered. Now, this case concerns an exclusion or exception whose operation, we are all agreed, depends upon reporting of the putative data to OFWAT, and we're all agreed it has a task of evaluating that data for at least 2 functions. The first is to assess whether it agrees that there is in fact a civil emergency of the severity as to fall within the definition supplied by the Civils Contingencies Act. And the second, I think we're still all agreed, is for it to evaluate whether or not the supply interruption in question is in truth caused by the relevant civil emergency, or is in fact attributable to some other more proximate cause, such as a defect in the remediation by a water company. Let's say it's not maintained its electricity generators, and they would have operated to prevent.
Why would it be binary?
Why would what be binary, Manny?
Or why would it be either caused by the civil emergency or by some defect in the system that was not being operated?
Well,
I mean, presumably, if you have a system that is operating at a very high level, it might be more resilient to a civil emergency. If you have one that's in a poor state, then it might be less resilient.
well,
You put it as if it was an either-or.
I accept that there's an assessment entailed in that sort of fault analysis as to the proximate cause of the problem in question. But where an event is identifiably attributable to a shortcoming on the part of the water company, we say properly construed, the C exception doesn't entitle you to.
So you say properly construed, it has to be binary.
Yes.
Thank you.
And that question reveals that what lies at the heart of this case is the proper construction of and/or application of that C exception. Because it's that governs how the supply interruptions of water supply caused by truly exceptional events, 1 in 30-year storms, it's not just extreme weather, it's a subset of extreme weather that we're talking about.
Can I just check the legal hierarchy? This is really an assessment or review of price controls under B12, I think, of the licence.
Correct.
And that's as in relation to performance assessments.
Correct.
I don't quite know how legally the performance commitments bite, but I'm told in different documents that they're pledges by the company. And then the reporting guidance, is that guidance issued by OFWAT as to what they expect people to do by way of performance commitments?
It's a very unusual exercise of construction in this case, because effectively what you have is reporting guidance that's settled by the UK working group, UKWIR, in the course of PC, well, just before the PC 19, so during the currency of what was called DG3.
Mm-hmm.
That guidance is then incorporated by reference in the performance commitments. And I'll walk you through how.
Because it's incorporated into the performance commitment.
Which are then adopted pursuant to the mechanisms in clause B12 of the licence. So they're, if you like, an annex to a condition to a statutory licence.
So it's guidance by a working group. It's incorporated into something called a performance commitment.
Yes.
And the legal status of the performance commitment is not an aspiration by the companies. It's something that has legal consequences because of B12.
Exactly. Because what it does is it authorises, we would say requires, changes to the parameters of the price control set every 5 years by reference to the data that is then plugged into the performance commitment. So it's a rolling mathematical adjustment by reference to data as it develops. And that's a reflection of the fact that these are, the clue is in the name, performance incentives. The formulae are designed to send signals as to pay to incentivise certain types of performance. And that's a function of the fact that this is an entirely regulated market. There are no contracts in play, at least in relation to residential water supply. Indeed, contracting is prohibited. And what the statutory regime effectively replicates is the messages about service quality that would otherwise be sent and set by the market. So what you're doing in effectively agreeing the performance commitments or setting them is setting the metrics that would otherwise be quality-based competition in the market. Now, it's important to note we're not talking about extreme weather in general here. We're talking about extreme weather that is so extreme as to amount to a civil emergency. So it's not enough that it's one of the named storms in a particular year, or even the worst of the year. It's an event effectively with something like a 1 in 30 year frequency. And that's rather shown by the facts of this case, because a number of water companies made applications under the CE exception in relation to Storm Arwen, which was a peculiarly impactful storm because of its direction, accompaniment by low temperature, etc. And it was only in Northumbrian's area was it accepted that the event was so severe as to amount to a civil emergency. And it's the first one, effectively since privatisation, that we're aware of that has reached that threshold. And that's an important optic, because when you see in the various documents the references to OFWAT saying the risk has passed for extreme weather, by and large it has. Northumbrian bears the risk for the particular winter storms that come in, and it has to have in place mitigation plans to address high winds or snowfall or heavy rains or floods that occur in the ordinary variation of weather patterns. So, viewed through a narrow optic, this appeal raises a pretty granular question of interpretation of the CE exception. It's an unusual document to be having to construe for the purposes of public law, being effectively a third-party working group report incorporated by reference. It's not a statutory provision or even a licence condition. We're all agreed, however, following the observations of Lord Carnworth, that the approach is the same. It's just the factors that are relevant for context that may vary. It's objective interpretation. And that means that the questions raised by ground 1A and B at the narrow level boil down to how to treat supply interruptions. Does the formula operate, as we say, in a binary fashion, with a decision at the end of the day as to whether or not to include or exclude any particular supply interruption from the calculus? That's how every single other ODI and PC works. We're all agreed about that. And we say there's no reason to suppose that this one alone is intended to operate in a substantially discretionary fashion. If that's wrong, and there's any discretion at all, you appreciate our alternative case is that the discretion is to be exercised only by reference to considerations of performance on the relevant metric. OFWAT's case, by contrast, is to say, no, the language of the provision is plain on its face, unambiguous, that it's discretionary. That's an argument that was not accepted by the judge. I ask you to note that. And they say that once there is such plain and obvious discretionary decision, all of their regulatory duties and considerations come into play, and they can exercise the ensuing discretion by reference to any consideration of relevance, not just performance, the whole gamut of statutory considerations. And it's important to note that their case is sufficiently wide and was accepted by the judge, that in fact all of the ODIs and PCs fall to be treated in this way. So even though the formulae don't contain discretion, their case is that when you come to doing the process of determination pursuant to clause B 12, 5 and 7, there is nevertheless effectively a discretionary decision as to whether or not to stick with the putative bargain contained in the performance commitment. And that analysis was expressly accepted by the judge. You can very well understand why that sets alarm bells for the water companies, my clients in particular, ringing on the plane of principle, because they think that these commitments are effectively the proxy for contractual commitments, and they are black and white, and there is no scenario in which otherwise the relevant commitments can be reopened, because then you don't have a comprehensible and sensible regime of performance.
Could I go back to a point that I was asking about earlier and just make sure that I've absolutely understood what the contention is that you stand for? Start from the position that, as I understand it, all supply interruptions have to be reported.
Yes.
And that's regardless of how they will have arisen. That data is collected and then it's analysed, and then it leads to a formula, and then that leads to an adjustment to the prices that can be charged.
Yes.
That in a case which, as you've pointed out to us, is extremely rare, if not unique to date, of a civil emergency arising, is your case that where it is accepted or established that the supply interruption was the result of the civil emergency, as opposed to the result of something else?
Yes.
That at that point, the data that is reported is to be effectively ignored, excluded.
Excluded.
Completely excluded.
Yes.
So that it doesn't become relevant to the charging formula. It's simply removed from the data that is being reported en bloc.
Absolutely so, my lord. The whole purpose of the exclusions where they operate is to determine which data is and is not relevant for the purpose of the metric that is then plugged in.
So how then, when let's consider then what, because that's that has all the beauty of complete clarity when it comes to saying what the figures are going to be, but what is the assessment that has to take place in order to know whether you achieve that happy state? It has to be determined whether something is a civil emergency.
Yes, and that we're all agreed it was.
No, but I mean, that may be the case, but one could see that there might be cases where that wasn't
Yes.
agreed. So who decides that?
OFWAT on our case.
Right. So OFWAT decides whether something is or isn't a civil emergency.
Yes.
And how do they, coming back to my previous point, decide whether the fact that water didn't come out of the tap in a certain place was a result of
Yes.
Storm Arwen, or whether it was a result of the fact that your kit locally never works?
Well, what links both of those scenarios my lord posits is that they're effectively exercises of adjudication, not policy formation. And I readily accept that in some cases there might be a dispute. For instance, southeastern water, which also said it was affected, might have said the storm in the southeastern area was so bad as to amount to a civil emergency. That would have to be an adjudication. It would challenge by judicial review.
That deals with the first point, which is whether it was an emergency or not.
Yes. The second point, there are two answers to my lord's question. The first is that issue doesn't arise on this case because we did the critical path analysis, and of the 25 million odd that was initially caused by the storm, we accepted, having commissioned Jacobs, a firm specialist in the area, that about 3.5, nearly 4, were attributable to shortcomings in our plans of mitigation. We put forward that analysis. It's never been engaged with or challenged.
That's what I don't understand, actually. How you could have asked for what was a partial exclusion on your case, because the 25 million, well, forget the figures for a start. Either the things have to be left out because it's a civil emergency, or they don't have to be left out.
Well, how do we get there? I'll explain that in due course. But the main way we get there is in the language of the CE exception, and the reference is to on the basis of and exclusion of civil emergencies which are effectively caused by the water company.
You look at each house and the time and say, well, that one actually could have been avoided. We know there was Storm Arwen, but if only we'd oiled the generator, it would have been fine. And you do it at that level.
But that is the nature of...
No, is that what your case is?
It is. Okay. That is the nature of the granular analysis in any event. Because when, for instance, you come to some of the metrics, we'll look at the above 12 hours supply interruptions, which is one of the bespoke metrics. The number of households that triggers an up and down performance is as low as, I think, 800 going down to about 500. And each household can make a difference. And that's why the process is one of exclusion. As it happens in this case, and to go back to my Lord's question, there is no argument on the causation. There's never been a suggestion that our analysis of which things are attributable only to the storm and which things are attributable
So
or
I've
fault.
written down, you have to separate out for each supply interruption whether it's caused by the civil emergency or whether it could have been avoided by other means. And you can only get the exclusion for the things that are caused by the civil emergency.
That's right. So
It's not that you can only get it. You're bound to get it,
Yes.
is your case.
exactly so.
You ask, you get.
Exactly so. So two adjudicative gateposts to pass. One is it a civil emergency? Two is the storm, and only the storm, the cause of the relevant interruption. If those two evaluative gateposts are passed, then as a matter of entitlement, my lord is quite right, it reverts to being binary because the data has been excluded from the formula. And that's how all the other exclusions operate.
So it was wrong to call it a partial exclusion. That was just a miswording. It was always a full exclusion, but a full exclusion for those things that were caused by the CE.
We'll look at the language of the exception. It's the CE exception. It's headed exclusion, and then the language is making a representation for an
No, but your
exception.
application for a partial exclusion, it was headed part. It was dealt with as an application for a partial exclusion.
It was, yes.
Yeah.
That's how we approached it. That's how we construed the provision.
And so what's this coming to in the real world? That you opened the bidding by saying that, let's see, 12.5% of this supply interruption was down to us, as you put it, might have done better.
A failed backup generator, which if it had been operational would have avoided some of the interruptions.
So you say it's 12.5%. Then there's a backwards and forwards and a backwards and forwards until what? I suppose OFWAT don't agree with that. They think that the responsibility lies more with you than you consider yourselves.
Yes, and that dispute would be a dispute effectively of factual evaluation, and if necessary, it would generate a judicial review. The judicial review would be the only remedy in question. That's the logical and correct analysis. But the critical point is what's happened here, and this is where the narrow dispute widens out to a broader dispute, is that where we get to is an opaque provision. The judge effectively doesn't conclude that it's clear on its face what it does, and it's required to be interpreted in context. We agreed with him and do. We don't think the totality of the answer is supplied by the language. We think the language is helpful. My learned friend thinks the language is a complete answer, open and shut case. But when you get to the full regulatory context, the fact that this is a scheme of incentives designed to be forward-looking, designed to send signals for investment, and designed as part of a process of price control becomes a very important consideration. Now, it's here that the regulatory scheme, which we think is the most important aid to interpretation, kicks in. The scheme of water and wastewater regulation is a complex one, but its detail is important in multiple respects, and I'll show you the detail. But the most important features, we say, are these. Firstly, that the scheme is predicated on a series of 5-year plans. Price control sounds rather Stalinesque. Price control settlements. They set the direction of travel for the required works, the required capital spend, the performance metrics expected, the glide path, to use the jargon of improvement. And they set the formulae for the annual adjustments that may operate within that 5-year price control. All of those features are then subject to a merits appeal to the Competition and Markets Authority, which is a specialist regulator. So the performance commitments and the contents of the formulae they contain can all be appealed on the merits. And our broader case is really very simple. The framework is one in which policy is set on a 5-yearly basis. And the policy choices here are highly complex and highly contentious. And there's a set of such plans in formulation now, PR24. And we don't need to labour the point as to how hugely public and political water industry regulation has become, with hot topics like climate change, population growth, sewage treatment, water company, financial engineering, etc., becoming daily news. And OFWAT will no doubt be using PR24 to make all sorts of policy choices about what capital expenditure it will require, whether or not to require CSOs to be improved or greater resilience to be provided, etc. All of those policy choices are then capable of appeal, but thereafter, once the policy framework for a 5-year period has been set, all that is possible is application of the policy to the facts. There's only one exception to that: interim determinations, which I will show you. There's a very high threshold to such conditions being triggered. The changes made where an interim determination are made are prospective in effect, not retrospective, and they're attended by a right of appeal on the merits to the Competition and Markets Authority. And so what you have is an utterly anomalous situation where effectively a policy decision, and when we look at the final determination, it is pure policy. A policy determination is being made outside the framework of the 5 yearly controls and in a fashion where it's incapable of any merits appeal of the kind that is obviously intended for the contents of the performance commitments. And we say any construction of a performance commitment that introduces such open-ended discretion and thereby effectively evades or subverts the regime of statutory appeal for control policy is obviously against the grain of the system and should be rejected, absent very clear language.
But under the licence, you are going to be done for the supply interruptions. It's only because you've got this guidance agreed by working policy that allows you to get out of the obligations. So the deal you struck was the deal in B12, pay. And what you want to say is, well, actually no, because I can take out of the mathematical formula certain things because the working policy recommended something that was incorporated. But aren't you starting from the wrong end?
With respect, we're not.
Oh, okay.
Because at the end of the day, what we are agreed upon is whether or not, and this is the question of substance, whether or not a very substantial and unique discretion is to be imported into the rules. And the question of construction is whether or not that discretion sits easily and properly with the regulatory regime as a whole.
So I'm following your argument very clearly. But when you say that something is a policy decision, are you in fact, is it the same as saying that it's a discretionary decision rather than a matter of calculation?
Absolutely. Rather than a question of adjudication.
Yes, I mean, it's just when you say a policy decision, I wasn't quite sure what you meant by policy. You're meaning that it isn't simply a matter of calculation.
It isn't simply a matter of calculation, and it isn't a matter of simple evaluation on the facts as to whether or not a test has been made. So whether or not there is a civil emergency, there's a statutory test under the Civil Contingencies Act as what a civil emergency is. Here are the facts. It's then a judgment, and it's either right or wrong whether the facts amount to a civil emergency.
The operation of something one might call a discretion or an exercise of judgment or something of that sort, as opposed to an evaluation of facts or a calculation.
Exactly so, my lord.
And considering that we're talking sort of, we're in hen's teeth territory here, that you told us that this is the first time since water was privatised that this issue has ever arisen. You'd have to accept, wouldn't you, that if you were conceptually right about this, then the gateway matters as you described them, which was this a civil emergency, and why did the water not come out of that tap?
Yeah.
That all of that introduces a whole level of assessment, evaluation, room for argument and dispute, which in the end OFWAT has to determine, subject only to judicial review.
Absolutely, but it's not replete with the types of policy choice that are evident in the draft.
Well, you're back on policy choice, and I'm not understanding that expression because it seems to me to misdescribe what we're talking about, which is that what you're objecting to is OFWAT having its own judgment to make that isn't based upon fact-finding and or calculation.
Yeah,
it's not to do with policy.
With respect to adjudication by reference to a particular legal standard is not discretionary. Not in
well,
the public.
if you prefer to call it evaluative,
It's evaluative.
I'm perfectly happy to use that. It's just the word policy that I'm finding not necessarily describing what you're concerned about.
I think when I show you the final determination, and indeed the draft determination, you'll get a flavour of what I'm driving at.
Well, what you're talking about is they take into account various matters in their evaluation, which you say they shouldn't. I understand that, but it's evaluation.
It's more stark than that with respect, my lord. There is, in the final determination in the relevant passages, no factual evaluation at all. It's effectively a decision as to how to do, what to do with the numbers, and where and what extent it's right or correct, taking into account all of the statutory considerations, to discount the number in question. And it's not by reference to any of the facts of the storm at all. It's by reference to much wider considerations about water regulation.
You take us through the structure, but assuming you're wrong for the moment,
Yes.
assuming that the reporting guidance doesn't confer an absolute entitlement to take things out of the formula, assume that, okay,
Yes.
against you,
Yes.
then what the determination does is the B12 exercise, and it has regard to the performance. And the performance now, because you haven't excluded the data, is you screwed up. Even though there was a civil emergency, you should have continued to supply water, and you didn't.
Well,
Therefore, you should be liable to the lot. But they say, although over 5 years this wouldn't be that significant, this was 1 year, and it wasn't entirely your own inverted commas fault, and they're going to split the difference. But that's nothing to do with the discretion under the reporting guidance. That's all to do with the way in which they have regard to the performance indicators. And on that analysis, it helps you rather than hinders you. You've really got to win on ground 1A, haven't you?
No, if I win on ground 1B, I get home. If I win on ground 2, I get
No, I understand that, but realistically, that's just glib. I mean, if you lose on 1A, and this isn't an exclusion from the data, thereafter it's got to be a B12 assessment, and either they can't do it at all because it's not been excluded from the performance data, or they are allowed to do it, in which case there's no harm in doing it in the way they've done.
What we say if we win in relation to ground 1B is that the only relevant consideration by which to make the discretionary assessment is performance.
Yes, but on this
that
basis, your performance is flawed because you've lost on 1A, you can't exclude the supply interruptions, and therefore you have failed in spades. And therefore, if you just have regard to the performance indicators, you pay the lot. And what they've done is something that's more favourable to you. They've said the words have regard to the performance factors as allowing them to split the difference.
That's the point that my learned friend made and was accepted by the judge. And our answer to that is that performance in condition B12.7 is not the output that is generated by the formula before the exception operates. It's performance by reference to the topic under the metric in question. In other words, if the metric is supply interruptions, how have you performed in relation to supply interruptions? And if we're in the realm of it being a discretionary evaluation, we can see that that would perform a basis on which to say, well, you performed very well but not perfectly under the storm, and so we're going to discount some of the number because of the faults in your performance in your mitigation plan. And we're going to take into account that absent this civil emergency, very rare storm, your trend of performance has been excellent by reference to supply interruptions, that this storm has created an aberration in otherwise excellent performance on this metric. That's the kind of consideration that we think would be legitimate under ground 1B. And that's the type of exercise very much focused upon how the company has performed by reference to supply interruptions.
And not just during the storm.
Not just during the storm. And the merit of that is that it is at least anchored in, first of all, the statutory language, or the language of the condition, and secondly, it operates the performance commitment in a way that still incentivises performance. Penalising a party for the adverse consequences of a storm doesn't incentivise performance. It produces perverse consequences. You have a terrible storm, you bust your metrics, it may remove any incentive to perform well for the rest of the period because your credit is spent.
Well, you'll come back to it, but at the moment you persuaded me that if it's a discretion to exclude and they don't exclude the use of discretion, you were lucky to get half of it back at all. But anyway, you'll come on to that.
Grateful. So the wider question is what the statutory scheme contributes in terms of construction. And we say any construction that effectively eliminates policy formation discretion and concentrates that in the 5-yearly process is one that accords with the statutory scheme. The judge agreed with that point, but found it outweighed by other factors. And that is basically the shape of ground 1. Ground 2 addresses the fact that if there is to be policy formation in the macro sense, we need to be told what the policy is in advance. Yes, to take my Lord's point, these events, their actual occurrence is as rare as hen's teeth. But the point about the incentives is it sends signals to everyone all the time about risk and liability in the event of risk. And that means when you're designing how you're going to spend your money for the 5-year period, you're going to have to take into account the risk signal that is or is not sent in relation to the occurrence of these very rare events. And it's that factor, the fact that these are incentives designed to shape investment decisions, that means that this is a context in which the common law duty of prescription arises.
You'll come back to it, but you'll tell us whether you mean that there's a duty enforceable by mandatory order to issue guidance, or you'll tell us whether any decision made under the exception and or under B12 is unlawful in the absence of such guidance in due course, I imagine.
I will do. And that point about signals is very important, because there are effectively, for every performance commitment and every 5-year horizon for performance incentives and the monies attached to those, decisions to be made by the water company as to where to spend their money, as to optimise their performance under the performance commitments as a whole. They may choose to channel more expenditure to, let's say, CMEX to improve customer satisfaction, because their assessment is that that's the area that they can best improve the net returns from all of the performance commitments as a whole. And so the companies have complex, forward-looking 5-year decisions to make about how best to maximise their revenue once the performance commitments are set. And that is, of course, what makes it so very problematic to introduce discretion, and with discretion, the potential for the rules of the game to change, because on OFWAT's account, there is the potential for very substantial discretionary changes within the formulae, depending upon the occurrence of a civil emergency and the extent of its effects. And while civil emergencies are rare, their effects are highly asymmetric, and their potential for damage by way of supply interruption, etc., vastly exceed the ordinary risks arising from daily life. So they're very rare, but they produce massive swings in the operation of the performance commitments because of their potentially huge downsides. And that means the adverse consequences of OFWAT's and the judge's construction is threefold. It exposes a water company to a change in policy, or a first revelation of policy, in the currency of any particular 5-year period. Secondly, by doing so, it in substance strips Northumbrian of the value of its appeal rights to the CMA. And thirdly, the combined effect of those first two is to substantially impede the business's ability to plan on the basis of what should be a clear risk allocation. And that planning brings with it the risks of inefficiency. And it is an important part of our case to note. I'm not asking you to take a decision on this point, but simply to note that the extent to which it's rational or sensible as a matter of regulatory policy to allocate risk for these extremely rare events to water companies is a highly contestable issue. There is a very sound economic basis says that the allocation of the risk of such rare and extreme events will drive inefficient investment decisions, because instead of, I mean, the ACME is a sort of snowplow decision. How many snowplows do you need? Well, if regular weather patterns are followed, let's say you need 5 snowplow to keep the roads open, but a 1 in 30-year storm might require you to have 30. It would be inefficient to keep the 25 snowplows for the other 29 years when they're not required. And yet a scheme of regulatory incentive that penalises you for not having the 30 snowplows is going to send an investment decision that risks people buying snowplows when by and large they're not needed. And that's the terrain of the debate. And it's a debate, we think, that has to go to the CMA. The danger of this case is that decisions on that basic topic are effectively then ventilated through an in-period determination which is incapable of challenge. Now, below, my learned friend with his customary gusto cited every single case that says substantive judicial review in a commercial JR context is nigh on impossible. It's the CELCON line of authority. And that may be true to have defeated the rationality case we were unwise enough to advance before the judge and we don't renew before this court. It very much cuts the other way in a circumstance where the regulatory scheme is designed, plainly designed, to channel disputes on policy to an expert regulator, the expert regulator to adjudicate. And we say that means the appeal rights point is all the more important because it's the CMA that should be deciding the merits of that inefficiency dispute. And that obviously feeds into the vice in the absence of policy. So to go back to answer my Lord Justice Lewis's question in part, we say the policy should have been adopted at the same time as the performance commitment so that everyone knew how the discretion that Ofcom says has always been there, OFWAT says has always been there, will be exercised, not least because that then facilitates challenge to the merits of the policy to the CMA before the policy operates to produce the potential inefficient investment that it might otherwise generate. Now, below, I referred to Jeremy Bentham's famous polemic, Truth Against Ashurst, and what he called dog law, which is changing the rules of the game after the event. If your dog does anything you want to break him of, you wait till he does it and then you beat him for it. And we have long since decried dog law in the criminal law context, which is the context of the remarks. Crown and Remington is the most famous endorsement of that. The problem, the loss of certainty that lies at the heart of this case, is a problem of dog law, because what we're having in this case is the incentives adjusted or very substantially set after the event. This is a case where effectively the full terrain of the incentive is only knowable once OFWAT has explained how it's going to exercise its discretion. And we say, having done so, it's obviously going to have to approach any other civil emergency for this or any other water company in a consistent fashion. That being so, we can't see any difficulty in formulating a comprehensible policy, not for every civil emergency in the world, but for the ones that are most obviously material to water companies. Sorry, my lord, you.
No, it's somebody outside actually, but since you've been interrupted, I'll carry on. What's going through my mind is that an evaluation which you accept would be for OFWAT to decide, subject only to judicial review, of whether something was truly down to a civil emergency, or whether it was down to you, or whether it was a combination of the two, strikes me as being an extraordinarily complex road to have to travel in order to deal with these one-off events. You are arguing for the benefits of certainty, but speaking for myself, it strikes me that what would follow from our acceptance of your argument would be a very considerable area of uncertainty in trying to tease out things that in reality probably can't be teased out.
Well, let's take that in stages. The first gatepost, civil emergency. We're all agreed that is something that OFWAT has to decide. So that's priced in one way or the other, whoever's construction you accept. It is, with respect, not that difficult to apply. Here, the
that wasn't really we're back on my second point. I was really focusing on the second point.
Yes, yeah, that's why I was going to take it in stages. The first point is not hard to deal with, not least because there were effectively various declarations in the various areas of the various councils.
What about the second point, which is
The
the
second
real
point,
point?
I'm coming to answer that. The second point does entail evaluation, but whether it's ground 1A and it arrives at a particular answer, or ground 1B, which is a more in-the-round approach to the topic of performance, the merit of both approaches is it still anchors the relevant performance commitment in the performance metric that is meant to be at issue, which is how is the company performing by reference to the topic of
It just seems to be a very difficult thing to have to assess in anything other than a broad brush manner. It's like you've got a crew on a ship and it's suddenly hit by a typhoon. How did the crew perform? Where does the responsibility lie? Does it lie in the dockyard? Does it lie with the captain? Does it lie with the crew? It seems to be. I mean, you're advertising something that has all the benefits of us being able to plan our 5-year plan and spend our money wisely and so forth. But actually, I don't really see how this is so simple under your...
With respect to them, I think it's provably not as complex as you fear for a variety of reasons. The first is that there is in fact no dispute on that front. So it's never been suggested that our approach to it is wrong in any way. The second is that the companies all necessarily have very advanced mitigation plans. They're required by the regulatory regime to have mitigation plans. And indeed, there are constraints on what money they can and can't spend for the purposes of mitigation. And there being mitigation plans in place, the exercise is working out, has the mitigation plan worked? Mitigation plans are only meant to go up to storms or events of particular severity.
We're in a different territory.
Yeah.
You'll probably solve this problem when you actually look at the documents. But the way I've got it fixed in my mind, just in case it's wrong, is you've got these water supply interruptions for X number of properties over X number of minutes or hours. And there are cost consequences attached, which you've calculated to be, I forget what it is, 25 less 3 million, 22 million. Because 3 million reflects water supply interruptions that you accept you could have avoided.
Yes.
But it does seem to me that what my lord says is right. If you're correct, the OFWAT people have got to go through each and every water supply interruption within the 25 million to see which ones are properly attributable to the storm and which ones are properly attributable to you not having in place robust systems or equipment, mean that even if there's a storm, the supply doesn't get cut off. So they do have to go through each and every supply interruption, don't they, if they're going to do it in the way that you say?
Once again, I answered that question yes.
Yes, that's
I
what they
answered
do.
yes before, and I answer it yes again. But I don't think, with respect, that that's such a terrifying or terrible terrain. You have an expert consultant report like Jacobs producing an analysis in question. OFWAT goes through it and says, we agree with this, we don't agree with this, here are reasons why. Challenging that type of determination for this or that or the other interruption by way of judicial review is not going to be an appetising prospect. And at least it then confines the scope of the debate down to, has the company performed or not? And these are all about incentivising performance. So yes, that is the correct analysis. But OFWAT never engaged with that topic at all. That's part of the problem. So those were the introductory remarks. Let me explain now. I'm going to proceed. I'm going to take you through the regulatory regime and the various bits of it in some detail. Then I'll very briefly address the facts. There's very little in dispute there. The main thing, I think, is to show you the draft determination and the final determination. And then I'm going to run through the grounds in turn. And I'm going to pick up the relevant passages of the judgment and my learned friend's arguments in the course of so doing, rather than approaching the judgment as a separate topic. So the regulatory regime, it's covered in the Statement of Facts and Grounds in great detail in B1, a reference for which is Core 13263. And there is also a very full account in Miss Navarro's witness statement, Section D, the reference for which is Supplementary Bundle 2, page 42. And there's more detail.
Just give me the references again. The JR was where?
413.
413.
Section B1, page 263.
And Miss
Navarro, Section D, Supplementary Bundle 2, tab 2, page 42. And there's also Mr. Beaver's first witness statement, Section E, that's Supplementary 1, starting at page 8. And Miss Armstrong's witness statement for OFWAT, Section C1, Supplementary 3, page 61. And that principally addresses the price controls. But standing back from that mass of detail, we think there are 5 key elements to this regime. The first is the target duties set for the Secretary of State and OFWAT by the Water Industries Act. The second is the fact of the system of appointment of water companies to act to discharge statutory duties for water and wastewater in the various areas. It's water only that we're concerned with. Third, there is the licence that flows from that appointment and the power to set conditions on the licence under Section 11, which has led to the standard condition B, which is at the heart of this case, and it's standard condition B12 that is then the provision that modulates price control for performance commitments of ODIs. That's the fourth part of the equation, what those ODIs are as governed by condition B and the in-period determinations that they provide for. And then lastly, there's the regime of regulated charges for residential houses set by the Water Industry Act, which ties in with licence condition B because it's licence condition B that shapes how much you can recover through the statutory schemes. So let's start with the Water Industries Act. Authorities 1, tab 14. Authorities in tab 1, tab 1, page 4. And here, and it's a commonplace of these types of schemes of economic regulation, you have the general duties set out first, and in particular 2A contains the so-called primary duties. The Secretary of State and OFWAT shall act in a matter best calculated to further the consumer objective, to secure that the functions of a water undertaker are properly carried out. So in other words,
sorry to be really basic. What is OFWAT when it's at home? Is it something created by statute? There's a bizarre statement that it's a non-ministerial government department. I don't know whether that's right or not. Is it a statutory body or not?
I think it is a statutory body. Yes. It's established
It's not
by
a
this
government
Act,
department then.
Yes, it was the Director General formerly, and then it was changed to.
Yeah. And is there a statutory provision that says there will be a body called OFWAT? It'll be full of very good people who know about economy.
There is. The Water Industry Act, I can speak from bitter personal experience, is truly enormous. We've tried to be responsible.
Don't worry, at some stage somebody will tell us that there's Section 1 or Schedule 57 which says if you know about water you can go on to what or something.
I think there's a particular chapter dedicated.
Right, okay, but there's a statutory body OFWAT.
It is, yes.
Right, okay, and the authority in 2.1
Yes,
and 2A is OFWAT.
So what section is it?
Section 1A on top.
Oh,
Section 1A.
right.
We don't have it in the bundle.
No, that's fine. Okay, thank you.
It's about 500 pages long, the Water Industry Act.
Section 1A.
Yeah.
Yes.
That provides there shall be a body corporate to be known as the Water Services Regulatory Authority, in this Act referred to as the authority.
Perfect, right, great.
So here you have the objectives, consumer objectives, discharge the function of a water undertaker, secure that the companies are able to finance the proper carrying out of their functions, and to secure the activities authorised by the licence and any statutory functions imposed on it are properly carried out. So that, and then E, to further the resilience objectives. So those are the primary duties. There are then secondary duties in 2.3 over on page 6. And they're secondary because subject to subsection 2A above. the authority shall exercise and perform the duties so as to promote the economy and efficiency on the part of the companies and to secure that no undue preference is shown and there's no undue discrimination. And then 4.6, so 2.4 rather, is also important, also on page 6. This is relevant to grounds 2. In exercising any of the powers or any of the duties mentioned in subsection 1 above, the authority shall have regard to the principles of best regulatory practice, including the principles under which regulatory activities should be transparent, accountable, proportionate, consistent, and targeted only at cases where action is needed. Appointments, then, they're governed by sections 6 to 12 of the Water Industry Act. We haven't included those in the bundle. Nothing turns on them. There are, I think, 11 such appointments as water companies. And then we can turn on in the Water Industry Act to sections 11 to 12, page 13 to 16. This regulates conditions. Section 11(1)(a) provides a power for the Secretary of State or the authority to impose such conditions as appear to be requisite or expedient. And then the critical provision over the page 12, this is the slightly indirect means by which the CMA comes to be involved. It's 12(2) and 3. Such conditions may provide for the reference to and determination by the Secretary of State or the authority, or on a reference by the authority, the CMA, of such questions arising under the appointment and such other matters, including in the case of references to the CMA disputes as to determinations by the authority, as are specified in the appointment or are of a description so specified. And then 12(3) provides in B that it's the duty of the CMA to determine any question referred to it by virtue of paragraph above in accordance with the principles under the Act. And 3D over the page provides for the reference to involve a group constituted for the purpose by the chair of the CMA, in effect, expert determination. So that's the means by which the disputes come to be before the CMA. There will be a condition specifying as much, and we'll see the conditions shortly. Then the last bit of the Water Industry Act is section 142. And this, the combined effect of 142, 1, 2 and 2A, means that for dwellings, the only means by which you can effectively recover the cost is by means of a charge pursuant to a statutory scheme. And there is effectively a statutory preclusion on contracting. And then over the page, 1431 governs the charging scheme, which has to be for a specified period of 12 months, and amongst other things, A, fixes the charges to be paid for any service provided by the undertaker in the course of carrying out its functions. Next up then is the licence condition, condition B, set pursuant to the power in section 11. And that you will find in the supplementary bundle at tab 24. And for your note, I'm going to show you the raw material. There is a very helpful explanation of how it works in Miss Navarro's witness statement, paragraph 17 and following, which is supplementary bundle, page 43. So looking at the primary materials at tab 24, condition B, you can see, is headed charges. Paragraph 1 explains the purposes of this condition, and this informs the purposes of all the ODIs, etc., adopted pursuant to it. it's to empower Ofwat to make determinations setting controls in respect of charges to be levied, and to provide for reviews of the appointed business to be carried out by Ofwat so that Ofwat can determine whether one or more price controls should be changed. This is dealt with in Part 3 under the heading Periodic Changes. And it's also 133, the purpose to enable the appointee to refer to the Ofwat for determination at any time the question of changing the price control. That's the interim determination for power, where they produce the existing price controls have a substantial adverse effect on the appointed business. And then 1.5 says the purpose is to enable the appointee to require the Water Services Authority Ofwat to refer to the CMA matters arising out of a determination referred to in subparagraphs 1.2 and 1.4. These matters are dealt with in Part 5 under the heading reference to the Competition and Markets Authority. So the topic of appeals to the CMA is sufficiently important to be headlined right at the beginning of the purpose of the condition.
Is what we're dealing with, the exercise they carried out under Part 3, covered by any one of these particular provisions? Which bit is it?
No, it's not. There is no reference to the CMA possible in the circumstances of this case.
Yeah.
That's the detail I'm going to show you.
But was the Part 3 assessment that they did, is it something that falls within 133 or something else? Or?
What we're dealing with here is a determination under condition B12, which is in Part 3A, not Part 3. So let me show you.
And having made that correction, same question, but in relation to Part 3A, is that something that falls within 1.3, the things you've just shown us, or 1.5?
In part, I'll show you.
Part, okay.
I'll show you. Mate. So, 9, condition B9, which is at page 358, deals with periodic reviews of the appointed business. You see, 9.1 says the appointee shall levy charges, that's section 142 and 143, in a way best calculated to comply with the price control or price controls determined by Ofwat pursuant to paragraph 9.3. Then 9.3 provides that in respect of the appointed business's retail activities, which is what we're concerned with here, Ofwat shall determine, having regard to all the circumstances relevant in light of all its principles under Part 1 of the Water Industry Act, what is the appropriate nature, form and level of one or more price controls in respect to the relevant part or parts of the appointed business, how the appointee shall, in respect of each price control applicable to it, demonstrate compliance, and for how long, compliance with the charging principles, and for how long such price control shall last, being a period of consecutive charging. So that's the periodic review, PC 19 being the relevant one for our purposes, PR 19. Paragraph 9.5 provides that the price control period shan't exceed 5 years. So that's the 5-yearly event. Then we come on to Part 3A, performance measure adjustments. 12.1, it's important you look at this because the judge found an effect in this that wasn't...
What page are we on?
Page 364. This is effectively the condition precedent to setting any performance measure adjustment. Ofwat has to do so, has to indicate its intention to adopt one of these mechanisms in the charging year before the review charging year. And the review charging year is defined by condition A, which is not in the bundle, but it's effectively the first year of any price control period. So what this provision says, and all that it says, is that if you want to adopt a new performance measure adjustment, you have to do so in the year before, effectively the last year of the previous price control.
And how did that work here? Did this apply? Were they notified, or was it different if a request comes?
Well, yes, they were notified in the relevant year by the 31st of December of all of the various price commitments, the performance commitments that were intended to be sought, etc. That process was gone through. The critical point is, all that this does is set a timing in advance notice warning.
Oh, I understand that, but you're telling us that it was satisfied here.
Yes.
That OFWAT did notify NWL by the 31st of December, the relevant year, that they may adjust to reflect the appointees' performances.
And what it is effectively one of the notes amongst many of the chime that everything must be done in advance.
Yeah.
It's not, as the judge thought, some independent power of decision. Then the appointee made by notice to OFWAT refer for a determination under this part the question set out in paragraph 12.5. So, should you make an in-period adjustment, or OFWAT may make such a determination on its own initiative. 3 and 4 then effectively address the timings for those in-period adjustments to be sought. 12.5 then provides, under this part, OFWAT may determine the question of whether there should be a change to the revenue allowed under, or as the case may be, the level of any price control determined under subparagraph 9.3 in respect of the appointee's retail activities, or the following in any subsequent charging year, and if so, the amount of such a change. There's an information provision duty at 12.6, and then the critical terms of 12.7. In making a determination pursuant to this part, OFWAT shall A. Consider the appointee's performance in relation to, so that's the key words, performance in relation to each relevant performance commitment in the period for which performance is being assessed, and in deciding for which charging year or charging years an adjustment should be made, shall consider both that and the appointee's expected performance in the current or one or more future years, but not including the next review charging year. And the point of that is, if you know, for instance, underperformance one year is going to be matched by overperformance the next year, instead of subjecting the customer to the wild swings, you can smooth.
Going back to 12.5, is that what we are dealing with here? There was
Yes.
a price control fixed by reference to performance commitments, and what the OFWAT people were doing was making a change to the revenue allowed. And the question is, should it be 25 million, 23 million,
Exactly.
or 3 million, whatever, I forget
Exactly
the figure.
so.
Yeah. So that's what we are dealing with here, is a decision under 12.5.
Exactly so, under 12.5 and 12.7. 12.7 is pointing you to the purpose or the relevant considerations in public law jargon for this exercise. It's the performance in relation to each performance commitment in the period for which performance is being assessed. And it tells you to look to future performance effectively for the purpose of smoothing. And then B tells you take account of the adjustments to the relevant price control which the Water Services Authority notifies the appointee under subparagraph 12 in relation to each relevant performance commitment in question. So there's a kind of net analysis. 12.8 then defines performance commitment. That's probably also useful for interpretation of the reporting guidance. It means a target or other measure of performance of the appointee in relation to the carrying out of regulated activities. So it's a target or measure of performance. Forward-looking, you need to know targets in advance. And then 12.10 is also relevant. Where a notification of a performance commitment is made for the purposes of subparagraph 12.1, in other words, where you've complied with the timing for adoption considerations, that notification shall be treated for the purposes of subparagraph 16.1, references the CMA, as part of the relevant determination made under subparagraph 9.3 or 9.4. So what that says is that where you have notified a performance commitment, it is then treated as part of the price control, and the performance commitment and its contents can be challenged on appeal to the CMA. So explicitly, built into this provision, there is the anticipation of the need to challenge the performance commitments that are set and a mechanism to do so before the specialist.
And just to make sure that we understand what that means in this case, that means that the requirement to report X number of properties being out of water for an hour is a performance commitment. Those are the things that could have been referred under 12, is it?
Absolutely.
Under 12.10.
All of the formulae, any aspects of the design, of the performance commitments, the glide path for improvement, all of those matters could have been challenged by way of an appeal to the CMA. Then you turn on to 16, which is references to the CMA.
Yeah.
Well, before we do that, can I just show you the provisions on interim determinations? They are at paragraphs 14 and 15, starting at 317. I'm not going to take you through the detail of all of these. They're extremely convoluted and complex provisions. But what they allow is effectively, where significant adverse effect is identified, a change in the basic price control. So there's a high threshold to be passed in order to get into these provisions, but once into them, they enable the price control to be changed. The policy it contains to be changed in period. They're well explained how they operate in paragraphs 42 to 44 of Mr. Beaver's second statement, supplementary bundle for page 100. The critical thing to note is that the exercise of these powers contains with it a power of referral or appeal to the Competition and Markets Authority. So built into section 14 and 15, there's a high test of exceptionality, prospective only change, and an appeal, because you're changing the framework of price control. Then part 5, references to the CMA, starts at page 383. And it's really 16.13 that's important for us, where the appointee disputes any determination made by the OFWAT under subparagraph 9.3. The appointee may, by notice given to OFWAT within 13 months or 4 months, etc., have the matter referred to the CMA.
That wouldn't apply here because it's a revenue allowance that they're dealing with under condition 12.5, I think it is, so they couldn't have appealed it here.
Yes, they could, because that's the provision I showed you. They can't appeal the determination.
No.
Of course,
No.
you're right. So I misunderstood your question. They can appeal the formulae, but they can't appeal the determination.
They can appeal the performance commitment, but they can't appeal the adjustment of
Exactly,
revenue.
which is why we're all agreed.
Which is your point.
Exactly. Well, we're all agreed that the only remedy in those circumstances is judicial review. And 16.2 is also worth noting. Sorry, there is a fault in the bundle, and it's probably easiest to take the condition from page 384 onwards, because it's a bit confusing. As the same page appears twice. 16.2 is at 385, and it provides that if you made a reference to the CMA, you levy charges in accordance with what OFWAT has determined in the interim until the CMA changes it. So, exactly as my Lord Justice Lewis has anticipated, there is no right of appeal for in-period adjustments, leaving us with judicial review. Put another way, if you want to challenge the design of a price control, you may go to the CMA when the price control is imposed. If you want to challenge the redesign, either of the price control in general, or the performance commitments, if the performance commitments are redrafted in period to address a significant adverse effect, again you can go to the CMA. But if there's just a challenge as to the application of the extant price controls or the extant performance commitments, ODIs, then your only option is judicial review. And that means there's an important cleavage point if, as we say, OFWAT's approach to the application of the C exception, in fact, is predicated on or has led to a development of an important point of policy about which a merits review should be possible. And that means, as I've already trailed, the shape of the regulatory scheme sends a very strong signal, we say, as to the interpretation of ODIs, that they should be performance and topic focused, and mechanical, not policy laden. Still less policy laden by reference to considerations of policy wider than the topic at issue, the particular performance metric at issue. So, of the 5 planks I mentioned at the outset, you've now seen everything other than the relevant supply, interruption, PCs and the C exceptions. Let me take you through those. Our case in summary on these is set out at 12 to 13 of our skeleton, and at 14 we explain the role of the reporting guidance. But let me again take you through the primary materials. Some further references which may help. Mr. Beaver's first witness statement, section I, deals with this at much greater length. Supplementary bundle 1, page 14. Miss Navarro, section E, supplementary tab 2, page 46 at 27 and following. So the actual supply interruption ODI PCs can be found in the PR19 determination, which is in supplementary bundle at tab 12. Sorry, tab 12 is the rationale. This is a generic document, a generic explanation for the purposes of these documents, and particular references here that are helpful. It starts at 191.
Well, what is this document, first of all? Is it going to include something which, because it's labelled price commitment, that takes us performance commitment, that feeds into B12? Or is it something else? Just help me.
So what happens at PR19, the final determination of the price controls, is that OFWAT issued effectively a generic explanatory document of what they've done, and then particular sets of price controls, ODIs for each water company. This document is generically explaining.
Yes, mine is a much more simple question. Which page do I put it next to know what gives it its legal bite? Is it an expression of clause 9.3 of condition B or something, or is it some freestanding thing that OFWAT have come up with? What's its legal status?
It's an explanation in generic terms of what OFWAT is about when adopting PCs and ODIs in general form. What the purpose is, how the regulatory purposes of OFWAT are being furthered.
So it's an explanatory document as to how they see things.
Exactly.
So it has no legal force at all?
Well, yes, I think it does as part of the context to the interpretation.
Context, but it's not something I could enforce as I want clause 9 refer to. It's an explanatory document, right? Okay.
But everything we're looking at here is part and parcel of the context that will help in.
I understand the context, but I want to know whether it's something that ties into performance commitments. But anyway, we've got it now. It's an explanatory document. Yeah.
So 191.
Yeah.
Explains the purposes of performance commitments and ODIs, and the purpose set out in bold, and then the outcomes approach gives companies the freedom to innovate and explore to find the most cost-effective ways of meeting those valued outcomes. It goes back to my point, which is a whole bunch of signals are sent, and then the company makes its own decision as to how best to proceed. Against the backdrop of more stretching performance commitments, in other words, the performance that is expected for each metric is getting progressively tougher, and there are stronger incentives to deliver on those commitments. In other words, the pounds per unit of excess goes up. If you don't conform with the commitments, the consequences get progressively tougher. And then over the page at 192, there's this, and I think this is helpful. Because performance commitments are a means to hold companies to account for their service delivery, in other words, to set the relevant performance standards, it's essential they're clearly defined. It's important also that performance commitments are stretching because this pushes companies to innovate in order to deliver better services to their customers. Properly calibrated, ODIs help align the interests of management and shareholders with customers because they directly link shareholders' return to the quality of service provided to customers. We protect customers against the risk of companies failing to deliver their commitments to underperformance standards. And then you see much the same theme also at the top of 193. Then the document goes on at 201 to address water supply water supply interruptions are defined at 195. Key sector-wide changes from the draft determinations. You can see the changes made.
So where are you? 201?
Page 195.
Oh, 195.
Key sector-wide changes from draft determinations. So the increasing the performance level to 5 minutes with an amended glide path. In other words, the extent to which improvements are.
Wouldn't it be helpful to show us the performance commitments first and tell us how they came into existence rather than explain what, or say what this document explains them to be? I mean, where is the performance commitment?
I'm just about to show you.
Oh, right, okay.
Can I show you one more reference in this document? You need never trouble my Lord again. Now, supply interruptions, page 201. I've now lost the reference. I'm sorry. I'll just take you straight to the commitment. Tab 13 then is the individual determinations of the detail of the performance commitments here fixed for Northumbrian.
And is it OFWAT who determines these, and they've got some legal power to do it? Because it's referred to in the document you have showed us as a pledge by the company.
Yes, so it happens in one of two ways.
Yeah.
Either OFWAT proposes such a performance commitment, or the company proposes one and OFWAT accepts it or accepts it with variations, or ultimately they are taken to the CMA and the CMA changes it. So effectively you've got three routes. You've got OFWAT proposing, you've got company proposing accepted by OFWAT with or without changes, or the product of some appeal to the CMA.
But ultimately something comes into effect which is a performance commitment, and because the conditions of the licence refer to performance commitment, by whatever process of gestation it occurs, there will be a document called performance commitments, and that is the thing that must happen
and I think
to be allocated.
I think all, I'll be corrected if I'm wrong, I'm sure Mr. Beale knows the answer to this. I think all of the performance commitments proposed by OFWAT manifest as common performance commitments. In other words, they are the same
for all the industries,
for all of the water companies.
All the companies, yeah.
And then the bespoke ones, I think, are invariably not suggested by OFWAT, but are suggested by the company in addition to the common ones.
But they acquire the legal significance by virtue of the fact that licence conditions refer to them.
That they're effectively adopted in conformity with the process starting with paragraph B12.1.
Yeah, okay.
So the first,
as a matter of interest, how frequent is the recourse to the CMA in the water industry?
Relatively frequent.
Relatively frequent.
Frequent, yes. There was no challenge to any of these particular.
No, I was just getting a general.
So I think Northumbrian and a variety of other companies did have appeals to the CMA at PR19, but it was on different topics.
Yeah.
The first common supply interruption is at 1.12, page 210. And you will immediately see the incorporation by reference. Detailed definition of performance measure, reducing interruptions to water supply is defined in reporting guidance for PR19 supply interruptions published on March 2018. That's the reporting guidance produced by the UKWIR. It is calculated as the average number of minutes lost by customer for the whole customer base for interruptions that lasted 3 hours or more. In other words, you tot up all the interruptions over 3 hours and you have a number of minutes that is produced, and that then is divided by the number of properties. And that takes you to an average number of minutes lost per customer. You can see that in the next box. There's also a definition of what constitutes a supply interruption. It's when the supply of water is at a pressure of 3 meters or less. Specific exclusions, none.
Where's that?
almost at the foot of 210. Measurement unit, hours, minutes, seconds per property per year, reported to 0 decimal places. Measurement timing, reporting year. Incentive form, revenue. Incentive type, outperformance and underperformance payments. Any other relevant information, ODI rate applies on a per minute basis. And then if you go on to 212, you have in effect what is the ODI that then accompanies the performance commitments. So what we've been looking at is the performance measure, and then this is the ODI. Well, this combined with what is at 213. So what the performance commitment levels table does is set by year the baseline number of average minutes exceeding 3 years for the particular year. So for instance in 2021 the average expected from which the overperformance and underperformance calculated is 6 minutes and 30 seconds. There's then an enhanced underperformance collar, 19 minutes, 17 seconds, and so forth. And you see the glide path, which is the changes. So if you take the performance commitment level, you see progressively the performance is expected to improve from 6 minutes 30 average per property to 5 minutes by the end of the relevant period. And then those numbers for each year are used to calculate the payments. You see that at 213. If you get under the number, you get an underperformance payment of 1.28 million. If you go over, you get an underperformance rate of 1.028 million per unit, and you get an outperformance payment of the same for every minute you go below the target.
And just so that I understand this, leaving aside the argument for the moment about the next document you're going to show us, is the 25 million or whatever it was, the mathematical calculation of the number of hours and properties and so on, that was just working out page 210 to 213?
It's the product of that exercise for the 3 performance commitments in question. And you'll see in the draft determination. You've got
so that's what would have happened if you'd applied B12 unless you made a revenue allowance or unless you're right on exceptions.
That's why we say it's all about formulae. Then the first of the relevant bespoke commitments, and this is actually the one with the greatest materiality in terms of the numbers, is 1.29.9, page 215. And this is just a metric of the number of properties that experience an interruption of 12 hours or more in a year. So it's not an average per property, it's just how many properties have lost their water for more than 12 hours. And if you look at the equivalent document at 2, you can see it's got all the same features, specific exclusions, none, the reference to the reporting guidance for calculation is in the second box. It's an underperformance and overperformance metric in period. And then you've got the performance levels, and as I mentioned right at the beginning, it's set by the reference to number of properties. So 500 properties glides pathing down to 400 properties is the metric of the number of properties experiencing more than 12 hours of loss of supply. And then you have underperformance and outperformance calculus over the page at 217. And this is a calculus without collars or caps. So Northumbrian proposed the bespoke commitment on the basis of this glide path, no collars and caps.
So what does that mean? This doesn't affect the amount of money?
Well, the collars and caps means that there's no stop to the sums produced by the formula. If there's a collar, that would set a maximum amount for the overperformance payment. You've got a cap sets a maximum amount for the underperformance amount you have.
I see, the payment amounts to 217, are they?
The payments, exactly, are at 217.
And is this part of the 25 million as well?
Yes, this is the most significant part of the 25 million because the effect of the storm was that some 8,000 properties were affected, I think, for over 12 hours. And it produced the great bulk of the sum at issue. And then the last one is another bespoke commitment at page 215. 218, sorry. And this is for interruptions between 1 and 3 hours. So the common standard commitment takes effect from 3 hours. This is effectively setting more exacting performance even below that. And it otherwise works in all material respects the same way as the 3-hour commitment. You see the same features, the same incorporation of the reporting guidance by reference. So in effect it fills in for delays below the common SI performance commitment. And again it has no collars or caps. So to sum up, on the face, all of these are entirely mechanical. They're a formula populated with factually reported inputs. You plug in the number of properties or the numbers of minutes of delay that are produced into the formulae, and it tells you whether to adjust up or down. And all of that is a perfectly comprehensible and predictable and knowable in advance measure of performance-related pay. And all of that accords with the purpose of an in-period determination as set by condition B12, B12.7 in particular. That then takes us to the reporting guidance, which is at tab 9 of the same bundle. It's important to note that there is a document of this kind for each of the relevant sets of ODIs and PCs. So this is the reporting guidance adopted for supply interruptions. The purpose of the document is to derive a metric for supply interruptions that consistently calculates the performance of water companies in terms of average numbers of minutes lost per customer. Why? This guidance seeks to enable companies to monitor and compare consistently derived and common performance measures for supply interruption. And you can see the driving force of all of this is consistency, predictability, and the ability to compare, so that the industry as a whole is working to the same metrics, and one company ultimately could be compared in terms of its performance against another. You can immediately see that if that's the purpose of the exercise, or to the extent that it is, the inclusion of truly exceptional events like civil emergencies would distort any process of comparison. Key principles, several key principles. Companies' own assurance process is used to check the data. They have a methodology for reporting. It's reviewed as part of their assurance. It's all to ensure the accuracy of their data. There's an assumption of continued improvement in the short and medium term through innovation, new technology, etc. The measures assume a clear and simple approach that can be understood by customers and regulators. That's another pointer towards effectively clear and mechanical outputs. The focus of the guidance is on annual reportings of supply interruptions. It's not intended as a definitive guide to the managing of the risk of supply interruption. And then at the foot, applying this guidance is likely to mean that comparisons of historical performance between companies and individual companies' previous performance may not be necessarily valid. However, it's anticipated that future individual year-on-year trends in performance will be possible. In other words, as the process beds in, the utility of comparison increases.
And again, I'm sorry to be difficult, but the status of this document, I know there was the working thing, but this is just guidance given by OFWAT on how they want the company to send the data of the number of minutes of properties interrupted, is it?
So it's guidance that was adopted by the UKWIR that was then effectively incorporated by OFWAT into the performance commitments and ODIs I've just shown you. So the industry working group produces this reporting guidance.
Yeah, but they can produce whatever guidance they want. That has no legal effect. How do they get translated into legal effect?
Because it's incorporated by reference in the supply, in the various PCs I've just shown.
Right, so the PCs is just the reference that you've shown us to reporting guidance can be found by the link that is this document. Is that it?
Absolutely. If you go back, for instance, to the common supply interruption PC at page 210, first box, reducing up interruptions to water supply, is defined in the reporting guidance for PR19 supply interruptions. That's this document.
Yeah.
So it's like a ticketing case.
Yeah.
It's like the terms and conditions have been incorporated by reference.
Yeah, so it's an OFWAT document. I appreciate it emerges from an industry review, but this is OFWAT's guidance that tells you what you've got to report, and you know that it's relevant to your performance commitment reporting obligations because it tells you in PR19 to look at it.
It tells you to look at it in the supply interruptions performance commitments. Each of the three of them includes such a reference. So that genesis is relevant to the context and the process of construction of this document, because you start with the fact that it's a document designed to promote consistency and clarity of reporting and to promote comparability of results and comparison.
Everything you've been telling us is about the context in which what has to be interpreted sits.
Exactly.
Right. So this is your run-up.
It is, and it's a very unusual context for this state. It's got a, as I said, it's like a third degree incorporation by reference, and the document itself was produced for one purpose and it's been used for an adjacent purpose, which is to measure performance commitments. So that the ultimate genesis in the working report is important. So if we go back to the reporting guidance, we had just got to the key bit, exclusions.
163.
163, exactly. The default position is that water companies manage the risk of supply interruptions and there are no exclusions. This measure covers planned and unplanned interruptions, so third parties drilling into your mains, that's still caught. The cause of the interruption is not relevant to the calculation of the reported figure, that is, asset failure caused by third parties will be treated as the same as the failure of the company's assets, and planned or unplanned interruptions are the same. In other words, you have to have in place the ability to react to third parties busting your water supply, JCBs, etc., and to be able to do so within a certain period of time, 3 hours on this particular metric. It's all about resilience to ensure the relevant response. So far, so good. All risk transferred. Companies may make a representation to OFWAT for an exception, that's the word used, an exception to be granted on the basis of a civil emergency under the Civil Contingencies Act, where the supply interruption is not the cause of the emergency.
Right, so we've now reached the pitch, as it were.
This is the particular provision that has to be construed. I'm really sorry if you feel
No, not at all. It's been extremely helpful because it's an unusual setting, as you say, but we've now arrived in the sense at what we have to construe.
So here are the operative words. May make a representation. Well, it's up to the company to decide whether or not to apply. If it's only one or two properties, or if you think your case as to whether or not there has been a civil emergency is a bit ropey, you may decide it's not worth the candle. So that's not any pointer to any discretion, other than in the company to trigger the process contained in this proviso. And I note that in their original response, this was the foundation in the summary grounds of resistance and detailed grounds of resistance. The word may was alighted on. Come back to that. We don't think anything turns on that. It's a discretion in the company. A representation, well, it's an argued case to OFWAT for an exception to be granted. Well, nothing turns on the word of grant if we're all agreed that OFWAT has at least the function of deciding whether there has been a civil emergency under the Civil Contingencies Act, and we certainly were agreed below that they have the function of deciding whether or not that, as opposed to some other novus actus, in fact caused the relevant interruption. So nothing turns on the word of grant because it's OFWAT that is making the decision on those two conditions precedent.
And this is for an exception to the default position that there's no exclusion.
Exactly. So the word exception means an exception to the rule of no exclusions.
Yeah.
In other words, it means an exclusion. The general rule is there'll be no exclusions, but the exception...
I'm not sure if that's sound logic, but
It's
See
certainly
what you say. It's an
a
exception
perfectly-
to the rule of no exclusion.
It's certainly a perfectly coherent way of reading the provision. And I don't suggest that the answer to this question lies in this provision and this provision alone. It is Delphic. There's no getting around that. There's certainly, and we agree with the judge, there is nothing here that indicates in clear and unambiguous terms that there's some kind of discretionary exercise to shape policy and make policy
Now,
decisions.
but leave that to one side. Look at the words for the moment. So the default position is there are no exclusions. Companies may make a representation to OFWAT for an exception.
To the default rule.
Yeah, to the default rule. That's what it must mean. So instead of having to report it, they wouldn't have to report it, to use neutral language.
Well,
And that's on the basis that there's been a civil emergency and it's not their fault.
no, it's all reported.
It's all
It's
reported.
the exception to the rule that there is no exclusions. In other words,
It's exception to the rule that you take the risk.
exactly. And so, what is the exception in question? It must be that where there is a civil emergency, not caused by the relevant company in question, which is a strong pointer to the fault analysis, we urge that an exclusion will be granted. In other
Sorry,
words,
I'm just not... Here, look. There's the mathematical formula. You have to tell them how many properties.
correct.
And there's no exclusion to that, subject to this argument at the moment. You've got to tell them the number of properties and the amount of time. And because of that, that gets translated into a money figure. Now, this says companies may make a representation for an exception. And I'd read that for an exception to the default position that there's no ability to exclude the data. So they can withhold the data. And because the data isn't sent, then it's not used to calculate the money.
Absolutely.
And that's what I understand it. But you seem to be suggesting now it's an exception to having to pay the money, which is slightly different.
No. I'm saying it's an exception to the rule that no events will be excluded. The decision that Ofwat
Excluded
makes
from what?
from the calculus, the measure definition that comes immediately below
Yes,
it.
but you're not saying, because I think this is the point my lord is getting at, you're not saying that you're exempt from reporting
No,
what actually happened.
no, not
Because
at all.
otherwise, I mean, unless and until you do that, nobody can have a conversation about anything.
Absolutely right, Manuel. The question that Ofwat has to decide is whether or not the relevant supply interruption counts as being relevant for the metric. And that then is effectively shown by the measure definition, which is the next thing that follows. Because here's the calculus that's done. And what you're deciding in the process of exclusion is whether the event in question and its associated minutes of delay above 3 hours go into this sum.
So this is the measure definition has nothing to do with the exclusions. We're into a new. The document has drawn breath, and we're talking about the normal situation of how.
Well, the measure definition explains what you do with the data that counts. In other words, the data that's
Yes,
relevant.
but it applies across the board.
Absolutely.
Yes. So the question is whether the CE situation, how that feeds into this
Absolutely.
this process.
So let's say, for the sake of argument, there's 1,000 minutes of delay, but let's say, for the sake of argument, 500. There's no dispute that they're attributable only to a storm. No company in the world could have stopped the delay in question. The question that is asked by the exclusion is whether those 500 minutes of delay go into the calculation in the measure definition.
Yes.
Are they
That's
part
the
of the
issue.
metric? Yeah.
That's the issue.
Yes.
And that's why we say the issue is a binary one. Because the question that Ofwat has to ask itself under this measure is, do the minutes in question count or not count? Do they go into the equation or don't they go in? And that is the only way to make sense of the heading and the reference to an exception. The exception is an exception to the rule of no exclusions. In other words, the data is exceptionally excluded from the measure. And that's why, with respect, Ofwat's approach, which is to effectively trigger that they say once the two conditions are traced, they just have a discretion as to what percentage to allow.
Well, that's different. That may be a part of the revenue adjustment decision, which may be separate. We're dealing first with whether or not the minutes go in or not.
No.
And can I just ask about...
With respect, my lord, it's very important I be clear about that. That is not Ofwat's approach. Ofwat's approach is that once there is a civil emergency and once the minutes are relevant for the purpose of the metric, they work out the financial consequences of the inclusion of the minutes, and then they decide how much of that sum by way of percentage to discount.
Yes, if you are right, they can't put the minutes in at all. If you're wrong, they don't have to allow you to withhold the minutes from the metric, but they say, as I understand it, that that's not the end of the matter because it's got to be a calculation of the revenue adjustment. And that exercise, which is what the final determination is said to be, allows them to split the difference in this case.
Yes, but their foundation for that, again, very important we're clear about that. Their foundation for that discretion is not condition B12.7 in and of itself. It is the language of this exception.
Well, then we need to see that. I thought that
their case is that this section is clear and unambiguous. That's the language in the summary grounds, the detailed grounds, and throughout my learned friend skeleton. It's clear and unambiguous that this section contains a discretion.
When you pause for breath, I'll say two things.
Yeah.
That may or may not be what Mr. Beale is saying, but I've got it fixed in my mind that there are two questions. The first is whether or not there is an obligation to withhold from the metric these things, or whether there's a discretion. So you don't have to withhold from the metric. But then I'm pausing and I'm turning over the page and I'm writing a new heading metaphorically saying, even if I don't withhold the figures from the metric, what I'm doing is a revenue adjustment under B12. And it may be that those words, the revenue allowance, I think the phrase is, may allow me to do something, given that I've not withheld it. So it may be that they don't decide, we're not allowing you to withhold it, and that's the end of it. It may be they can not allow you to withhold it, but allow you to be generously treated. That's one thing. The second thing, before I forget it, at 210, why is there the word none next to specific exclusions? Why isn't there a specific exclusion, civil emergency only?
Because the default rule is no exclusions. And it's not, an exclusion has to be capable of application by the company itself. So in all the other metrics, the exclusions are effectively self-policed. You're told you don't have to report this or that after the date.
So hang on, at 210, if you look at 210, it's got specific exclusions. Yes. Why couldn't it be OFWAT determined civil emergency?
It could have been. It could have been. And it's, you know, it's, yeah. Look, I accept it's a point pointing the other way. It's, part of the picture of confusion.
But is it relevant to interpreting what?
Yes, it is relevant.
163 means, right?
Yeah,
okay.
It is relevant. All of the document is relevant. But our submission is, you certainly don't arrive at a position of clarity in identifying the existence of a general policy-laden discretion from this document. The terms of the exclusion are pretty opaque. And we think that that's a function, ultimately, of the fact that this document was designed for a different process. It was designed to standardise how the data was in general reported. And before the UK working group standardised all of this, every single company had its own different ways of reporting these types of data. So this was a kind of process of standardisation of how these events were reported. So that's the language. There's certainly no express reference to discretion. The judge is correct. We think when you look at the exclusion in the context of the measure definition, it's apparent that what is being triggered is a decision as to whether or not to include the minutes or not in the measure definition in the calculus. And it is a binary decision as such. And that means that this reporting guidance and the PCs that work upon it work like every other performance commitment, which have that same structure. And
are the key words on 163 understanding what is meant by an exception?
Yes.
I mean, that's what it comes down to.
We say that is the key thing, and once you understand it's an exception to the rule of no.
No, but I mean, I'm not trying to argue out one way or the other what it might mean, but is the I mean, having come to the critical paragraph within the broader context, the critical words within the critical paragraph seem to be what is meant by an exception. What does that
absolutely
empower OFWAT to do in response to your representation?
Exactly so, my lord. May and grant, which are the words OFWAT have alighted on. We don't
granting an exception.
We don't think really shed much light on anything.
No, sorry, but I mean, what is it that OFWAT do when they make an exception?
Yes.
What is the scope of their powers in that respect?
That is exactly the issue. The other words that are important are the words where the supply interruption is not the cause of an emergency.
Yes, that's a cause for a separate evaluation, I understand it.
Absolutely, and that goes with the words of on the basis of a civil emergency. So those two concepts go together, and they're the foundation for our causation concession.
I understand that you can give the word granted some meaning other than an exercise of discretion, because you can say, well, it can only be granted, it can only be given if they're satisfied it's a civil emergency and you're not the fault of it, and therefore it has meaning.
Yeah.
But one could take a different view and say, yes, that's 2/3 of the meaning, but another bit of the meaning is it's a discretion, and granted means we think it appropriate. But you say that's just what we've got to decide.
I am not going to attempt the argument that everything is answered by this provision, because it plainly isn't. It wasn't drafted by lawyers for this type of, you know, it's not like construing a statutory instrument produced by a parliamentary council.
So granted could be an indication that it's not automatic, but it could be explained by it being a reference to another exercise that has to be gone through, whether it's a civil emergency and whether it's fault.
Because an evaluative judgment has to be made before the minutes are excluded from the formula. That's our point. So, standing back, there is nothing express here that answers the question of whether there is or is not an discretion. A discretion sits at variance, we would suggest, with the identified key aims or principles or objectives set out earlier in the document, which are all about consistency, comparability, etc. There's certainly nothing to suggest that any considerations other than performance under the relevant metric are to be taken into account. All of this suggests, for the purposes of condition B12.7, that the performance issues in relation to supply interruptions are narrowly cast.
I mean, say it's a little bit of an emergency, but not the end of the world. It's all taken out. But if it's pretty bad, but not quite across the threshold, it does count. It seems, why would they take such an absolute line? You say there's just got to be bright lines.
Well,
you get a bonus if it's...
Generally,
awful.
it's the government or the regulator defending bright lines.
But you have few, yes.
And that there are bright lines. We find unproblematic for ground 1A because rules of these kinds contain bright lines. Contracts contain bright lines. How you define your force majeure clause is a bright line. How you define the circumstances of defective performance that entitle you to terminate a contract. They're all bright lines. They're categorical decisions, and obligations work on the existence of those types of categorical decisions. That's point one. But if we're wrong on ground 1A, then that might be something of relevance for ground 1B. You look at, say, performance in other storms that aren't civil emergencies. If it don't produce supply interruptions, the company looks robust and like it's performing well, will give you everything that's caused by the storm.
So the context is you should pay for this under the performance indicator unless it's taken out. And if they decide not to take it out, but they want to give you little bits instead, you're marginally better off than you would have been. But you say, no, because this reporting guidance was always meant to protect you from having to.
There's an obvious charm of that argument that appealed to the judge. The problem with it is it assumes the very premises of the thing in debate, because it's an argument that only works if you assume to begin with that the exercise is discretionary. If you assume that the exercise is discretionary, then obviously that analysis is correct. If you assume, on the other hand, that where OFWAT finds that there is a civil emergency, and where OFWAT accepts that the civil emergency has caused the supply interruptions, it then has to take the matter out of the metric, then that is what the metric has determined. So that argument, which appealed to the judge, is completely circular with respect.
Or on the other way hand, it could be relevant in this way. You persuaded us that this is something that must be certain and absolute, and if there was any doubt about this, it should be something that should go to the competition authority. But another way of saying it is, no, this is actually a concession. You knew from the deal that was struck that you were going to pay for everything. You knew that you might be able to get away with civil emergencies. You haven't been able to get away with civil emergencies, but they've got to make a revenue adjustment, or they can make a revenue allowance, and that's what they've done. So it's not so awful for you as one might have thought. So it can't be the answer, but neither can it be the opposite answer, in the sense that it may well be, depending on the outcome of what we think the words mean, that the balance that was struck was either you pay, but the hope of being let off, or, as you say, you don't pay. But in neither case does the end result help dictate the meaning of the words.
The choice is between a reading that says there's a total transfer of risk, except in these circumstances where these two conditions are met, at which point the events come out. That's the binary mathematical logic of our approach. Or an alternative approach that says risk is not concretely allocated, it's all allocated subject to a proviso that we may decide in our discretion where these marks, the risk doesn't or doesn't completely transfer. Those are the two.
I mean, would you be forced to accept that it would have been a more obvious way, perhaps, of achieving the result that you say is the right sort of result in this situation, if under exclusions it said there are no exclusions except that where there is a civil emergency, the hours lost as a result shall not be taken into account.
Do I think that the clause could have been more accurate?
No, but I'm saying that if that's what any of us was actually thinking of achieving, namely that civil emergencies don't count,
yeah,
then there's a much easier way of saying it.
There undoubtedly is a better way to draft to reflect that.
Well, exactly. So we have to consider what the implications are
But I would say
of Route 1 not having been adopted.
I agree. Forgive me for interrupting.
No, not at all.
But conversely, if it says what Mr. Beale says it says, it could have been much better drafted to convey that impression too. And the problem is that either way, whichever contention you're looking at, the draft is defective.
Anyhow, we'll let you get on.
Which is why this case actually turns upon all of the wider contextual factors, because it's only those that actually help you answer the question at the end of the day, what does this provision actually mean, or how is it best to be made sense of objectively in its full context. So the last thing I just need to show you is the UKWIR. We addressed this at 15 to 16 of our skeleton, page 22 to 23, and that has some useful references which I don't have time to pick up, but it's in supplementary bundle tab 6, page 115. And even the heading of this report is helpful because it makes the point set out in the key principles that the real aim of this document is not the invention of OFWAT discretions or anything of that kind. The real aim is to ensure consistency of reporting of performance measures.
So, again, I hate to be grim, but what's this document when it's at home, and how is it legally relevant to the interpretation of either the performance commitment or the reporting guidance?
Statutory context, I mean, not statutory context, construction, context for construction. This is the report that explains the adoption of the reporting guidance.
So whose report? OFWAT?
No, it's a report whose authors are Mr. Archer, Brettel, Ingle or Jones or Messrs. Project steering group composed with people principally from industry, but with Mr. Ashley from OFWAT, Mr. Barnes from the consumer body CC Water, Ms. Wallace from the Environment Agency, Rob Wakely from Environment UK. And it is the Water Industry Research Limited report on how to promote consistency of reporting. And the objectives of the drafters of the reporting guidance must inform the construction of that reporting guidance, because it explains what they were trying to do with the reporting guidance. That's set out at 117. UKWIR initiated this project, the active involvement and support of OFWAT, etc., the people I've shown you are on the committee, with the objectives to review each of the three proposals on leakage, supply interruption and sewage flooding, including key technical parameters for appropriateness and effectiveness.
Does this document refer to civil emergencies?
Well, I'll show you, it does in turn, yes. When you get to supply interruptions. identify specific and exceptional defined circumstances, if any, where derogations, that's exclusions, from the standard approach and technical parameters may be appropriate. Identify and undertake further work to develop the reporting methodology on specific areas where needed to produce effective detailed reporting specifications. That's the reporting guidance, which can be adopted as a basis for consistent reporting, and guidance that's sufficiently detailed for company practitioners to apply consistently and regulators to understand, while key metrics are understood. And then conclusions. The primary output of this project is reporting guidance, like what we've just been looking at, for use by companies to ensure that their reported information on leakage, etc., is not just robust, but reported on a consistent and comparable basis. So that ties in with the key principles we've just been looking at. The calculation assumptions to be applied here be made simple and as customer-centric as possible in order to achieve consistency of reporting and customer trust.
Whereas the last paragraph confirmed that the output of this project is intended to form the basis of the thing that you've been showing us.
So it doesn't affect PR14, but is intended to form the basis of the next price control. And then benefits, page 120, consistency of reporting, greater clarity of reporting, clear definitions to promote meaningful expectations of the water industry, industry ownership of the reporting, providing a framework by which consistent reporting can be maintained as the regulatory environment evolves. And then page 122 explains why, penultimate paragraph, why the three measures, including supply interruptions, were chosen. It would improve confidence in the comparability of information for those. So in other words, leakage, supply interruptions and sewer floodings were felt to be areas where comparison between water companies would be useful and meaningful. You get a 1, 2, 3 after the bullet points, the primary output being the reporting guidance to ensure that they're robust and reported on a consistent basis. And then the methodology at 1, 2, 4 is important. I'm not going to read through all that, but that is all relevant context. And then 3.2 at 1, 2, 6 and following deals with the topic, one of the three topics of supply interruptions in particular. 1, 2, 6. Explaining what the interest in supply interruptions was, and then that's picked up again. We filleted the document at 4.2, explaining the guidance document adopted for supply interruptions. It's included in the appendices, so the reporting guidance we've just been looking at was appended to this report. Calculations assumptions have been made as simple and as customer-centric as possible. The objective, clear consensus for a metric that consistently calculates the performance of water companies in terms of average minutes left. And that makes our point. This is all about making a consistent and comparable metric, which the injection of discretion cuts right across. And then you go on to 4.2.3 at 128, which deals with exclusions. And as the judge points out below, it's not particularly helpful. A key area of simplification was the reduction or elimination of circumstances which would be acceptable as exclusions. Exclusions are to be kept to a minimum and shall be consistent with the reasonable expectations of an affected customer. And that, we say, is consistent with the CE exception being an exclusion. And we say it's also consistent with it being confined to cases of truly exceptional weather event where no company could improve its performance, because customer probably wouldn't expect a company that's done all it can, send its employees out in the driving snow, sometimes at great personal risk, to energise the energy supply. It wouldn't be expected for them to be penalised in those circumstances. So that's that document.
Well, so we need to go to 134 to 135, which deals with civil emergencies and produces exactly the same words.
Yes. Yes, this is the reporting guidance. It's the same document.
It's the same one, is it? This
Yes.
is the appendix to it.
Yes. So the text is the same. I think there's some very minor non-material textual differences.
The other one's got off-water.
Yes.
That's where it came from.
That's where it came from, and it is materially identical terms.
So they produced this, and that was then taken up by OFWAT, and no material change made to it.
Correct.
Right.
Which is why UKWIR and what it thought was about is an important part of the context of interpreting the document. I know I have to keep coming back to explain that to my mind, but that is my target, so at each stage. Now, my second topic I can take much more quickly, the factual background.
Right, so the first topic was the regulatory scheme, is that right?
That's right, and I've shown you all of the relevant regulatory provisions, the supply interruption commitments, the licence terms, and the supporting background materials that would help with construction. The factual background, I'm not going to labour the point, it's all very clearly set out in the evidence and the decision, and there isn't really any material dispute. Storm Arwen was an exceptional storm, creating exceptional damage for a variety of reasons, not least the prevailing wind strength, direction, the accompaniment of profound cold weather, snow, etc. We're all in agreement about that. There was a very large number of supply interruptions of varying duration as a result, a large number of which were supply interruptions over 12 hours, so impacted specifically the second metric. And on the basis of that, my client commissioned the independent firm Jacobs to do the analysis, what could we have done better, etc. It was on the basis of their reporting that we identified a figure of 3.375 million that we said was our fault, and we effectively wanted to have trimmed from the £25.78 million, which turned upon the inclusion of these supply interruptions in the three metrics. So we were effectively asking for an adjustment of 22.4 million, the difference between the two. And as we explain in paragraph 23 of our skeleton, page 24, OFWAT's initial draft determination, which is in supplementary bundle tab 18297, refused to make any change at all to the sum produced by the ODIs. OFWAT accepted that there was a civil emergency, but decided to treat, in its discretion, all the supply interruptions flowing as being countable, notwithstanding the C exception. The reasons for this discretionary decision were various, but came down to the contention that this reflected an appropriate allocation of risks to the assumption. And you can see that in particular at 303 to 305, and especially at 305. And that reasoning is quite different to the reasoning adopted in the final determination. It's useful if you have the time to read the two against each other and to see just how the policy analysis has changed. We then contested that draft determination on the basis it was predicated on a misread of the C exception, and we made the argument that you've heard as to the binary nature, the decision to include or exclude, being the proper way to approach it. And that culminated in the final determination, which I will take you to. It's in core bundle tab 14, page 296. Now, I should say that we accept that the judge, in his judgment, 39 to 40, page 102 of the core bundle, identified the absolute heart of the reasoning. (101 to 102). Paragraph 38. That's really the heart of it.
Sorry, I've lost your reference. What page are you on?
101 to 102
Thank you.
is the judge setting out what is effectively the core reasoning in the final determination.
Right, so you're referring to page numbers.
Yes. Paragraph 38, page 101 to 102. And it's 38, 39. culminating at 40. And that, in our submission, is the heart of the final determination. But let's just look at the final determination for its structure. Background is at 297. And it is acceptant of the fact that these are incentives intended to incentivise companies as to how to deliver their committed, that's the important word, committed levels of performance.
Well, it's helpful to start at the top, and what this actually says it's doing, and you say it was wrong to do it in this way, is that deciding on the adjustment under Part 3A.
Yes. Yes. But when you look at the contents of the relevant decision, what you'll see is that in effect it's devoid of any real factual analysis. There is no factual evaluation or factual dispute between the parties. After the relevant positions of the parties are set out, OFWAT, I'm doing that, sorry, has alighted upon page 298 its requirement to make what it calls a bespoke adjustment. That's the language.
That's the 50%.
That's the 50%. And the actual analysis contained in this document is all on the plane of policy. So if you start at 307, you have consideration of the stakeholders' responses. And for instance, you'll see, for instance, Anglian and other water companies have interjected in response to the draft determination, effectively supporting us, saying this is not how this is intended to operate. You can't make the rules up as you go along. 307 through to 309 is a sort of general review of the policy. Then there's a consideration of the impact on the wider framework.
Just you understand why you're taking it quickly, but these comments on these are stakeholder responses to our draft determination.
That's right. And the very fact that everyone else has been consulted.
You're not unhappy about that.
No, but it shows that one's in the terrain here of a policy decision, because whatever's decided here is going to be material for everyone else looking at and affected by this clause. And they basically then explain how this fits in the overall framework, how it fits within the outcomes framework, what its impact on the wider framework may be. So that's 310 and following. For example, in considering the package as a whole, we consider whether our outcomes regime may create unwanted incentives to invest so as to minimise risk in an inefficient way, which would not be in the consumer's interest. That's the snowploughs point. Ultimate paragraphs. Further, we don't consider our decision in this final determination on whether or not to intervene will otherwise affect companies to invest at PR24. As now, this is important, companies will be funded to meet a level of resilience through base expenditure. We'll also consider companies' requests for additional expenditure. In the end, we would not expect to make enhancement allowances to be resilient to very rare events. So what they're saying is, you've taken the risk of this, but we're not going to fund you to meet these relevant events.
Going back to what I asked you a moment ago, you're not objecting to stakeholders being consulted, but you are saying, as I understand it, that they're being asked about the wrong thing. Instead of what is taking place here, which is a very high-level survey of what's the right thing to do, you would accept stakeholders being asked for their comments on which bits of it were your fault and which weren't, or whether this was a civil emergency.
No, my lord makes a very good point. What is going on in this process is effectively the other water companies who have an interest in these provisions are being consulted about effectively which policy choice as to how to operate these clauses should be made. When in fact, properly construed, the only question should be, is there a civil emergency? and are these particular interruptions the fault of your failure of performance during that emergence?
Yes, but I mean, but this, if this is effectively, it would seem to me to follow from the logic of your submission that this is a consultation process about the wrong questions.
Absolutely.
It's one in which your client, as it happens, played its full part.
Absolutely.
If we go back to page 300.
Yes, and the judge.
4. Yes.
The judge makes some play of the fact, well, there's no unfairness because you've been consulted, and effectively the policy that has been formed through a process of draft determination, representations, etc. The problem with that is the policy is only formed at the very end of the process in the actual draft final determination, which is radically different to the position in the draft determination. And this is dog law, because the actual policy is only formed after the event, after the relevant...
But that's one way of looking at it. Another way of looking at it is, this is all irrelevant. You're either right or you're wrong. If you're wrong, then they took it out of the matrix and they said, but we're going to give you half. If you're right, it doesn't matter what they say.
You're of course right, my lord. You're absolutely right. What I'm trying to show you is what the process actually going on is. And what the process actually going on through this process is policy formation. They are deciding, as a matter of policy, for the first time, how to exercise their discretion. There's never been any indication as to how the discretion they had is going to be exercised beforehand. They're effectively consulting the industry. How should we apply this discretionary power in these circumstances? And that's why there's all this high-level stuff about how it fits in our overall framework of PR20, PR19, etc., and absolutely nothing about the facts of the case, because it's not about application at all. It's all about policy formation.
Well, they do say a number of times that it's not automatic, and therefore they're not going to give it to you automatically. So they engage at one level with what your case is,
course.
And you say they've got it wrong.
Yes.
They needn't have done all these pages. One page would have been enough.
But what I rely upon this document to show is that the output of this process is a decision on the realms of pure policy, rather than driven by the facts of the particular case.
But so what?
As to what
if you're wrong, you're
agree.
entitled to.
But it just feeds into my point, which is that those types of policy decisions should be made at the time of the price control, and they should be explicit at the time of the price control, so that they're capable of challenge to the CMA.
No, because the price control is the performance commitment, and if you're wrong about the performance commitment must exclude civil emergencies from the matrix, the performance commitment, the policy framework includes you are liable for all of that, and you have the chance to appeal on that. And what is happening, if you're wrong, is a very generous exercise of discretion by them when they do the revenue adjustment. But all of this doesn't dictate the outcome. You also mentioned, oh, it's policy and we've been deprived of the opportunity of going to the CMA. It all depends. Is it that the performance commitment requires them to exclude civil emergencies, in which case you're right? Or is it the case that the policy was commitments don't exclude as a guarantee storm damage like this, and thereafter it's how within the framework that you could have challenged they're dealt with. I don't see that the reference to policy and being deprived of appeal rights really help very much, because they all presuppose that you won the argument, and the question is who wins the argument first.
With respect, no, my lord. As the judge accepted rightly, and there hasn't been any appeal against this, the absence of a right of appeal in relation to a decision-making process that will generate pure policy decisions is a strong pointer against the existence of the discretion. That's the point we make. All I'm pointing to this material to do is to make my basic factual point, which is that what is going on here is not a process of evaluation. It is a high-level policy decision as to the appropriate policy response to be taken using the discretion that they have assumed to exist. And my point is that that is axiomatically the type of policy decision that the regulatory regime anticipates being folded into the 5-yearly control and capable of challenge to the CMA. That's my point. There is no factual engagement in this document at all. So, can I then proceed to the grounds? The first point, ground 1A, and that's where I'm going to spend the great amount of my time, there is no dispute between the parties as to the nature of the task of interpretation. We've included in the bundles the cases of O at tab 22 of the authorities bundle and the Lambeth case at tab 19. And I think we're all agreed, as was the judge, persuaded that it's Lord Carnwath's speech in Lambeth, in particular applying the Trump International case, that sets out the operative test. It is objective interpretation. That is the test whether or not you're dealing with an Act of Parliament, statutory instrument, planning consent condition, which was the factual context of Trump, or in this case, a licence condition, or indeed a document incorporated by indirect reference through a performance commitment of the kind of the working group report. Once it's incorporated into the architecture of the condition, it must be objectively construed. It's a context-specific exercise. Whether or not you're dealing with primary or secondary legislation or a licence condition and how it's formed are all going to provide context-specific pointers towards interpretation. Parliament doesn't have a single author, so that informs the rules. Statutory instruments do. Here, there is an author for the guidance. It's the UK Water Industry Research Group, and that's why that's a relevant source. So it's all a function of context. But there are, I think Trump International aside, there are no really comparable cases of statutory or of public law interpretation we can think of for a document of this kind. Round 1A posits that the C exception should be operated in a binary or mechanical fashion. You've got my primary position in relation to that. There are 2 evaluative exercises. Once those evaluative hurdles are passed, the relevant event is excluded. Anglian actually put it very nicely in their response to the consultation. The response is quoted in Mr. Beaver's witness statement at page 10 to 11 of the supplementary bundle. The question of whether an exemption is warranted should therefore be determined by questions narrowly related to the case in point, such as whether a civil emergency took place and was responsible for the service failures, and not an in-the-round assessment of whether a company deserves an exemption, which is, of course, highly subjective. That really is the case in a nutshell. We say that our interpretation is supported, not conclusively, but nevertheless supported by the language of the provision, and you have my basic submissions on that. The words may and grant don't assist. The word that does exist is the word exclusion as a heading. The word exception, once you understand it to be an exception to the rule of no exclusions, in other words, an exclusion, and the words on the basis of, combined with the rider about not caused by the water company, which is a pointer to the causation inquiries. And that approach produces a PC and an ODI that works with tolerable certainty on a mechanical fashion like the other PCs, in a way that sends clear and comprehensible investment signals. You must cater for third-party risk, you must cater for all circumstances, but not the hugely asymmetrical downside risk of very rare civil emergencies. That you don't cater for. That is perfectly sensible and comprehensible as a matter of regulatory policy. Indeed, the evidence shows that's what other regulators do in their like circumstances. So no one could suggest that such an approach is somehow regulatory incoherent in circumstances where it's effectively what Ofgem and others do. It's an area in which different regulators can take perfectly reasonable approaches. And it's important to note, paragraph 30 of our skeleton has the references to paragraph 25 of my learned friend's skeleton below, that it was accepted by OFWAT that they had to do an evaluative exercise, both as to the existence of the CE, the civil emergency, and as to the causative effect of that on the relevant supply interruption. So that was accepted below. And once that's accepted, one has to ask, what is the need for, what is the basis for, what is the hook in the text for, effectively a second bite of the cherry, where you not only read the relevant provisions as requiring that causative inquiry, but you also read it as importing, quite exceptionally, quite anomalously compared to everything else, a wide discretion on grounds of policy. Now, the judge dealt with these black letter considerations very briefly in his judgment at 67 to 70, page 114 to 5 of the judgment. His end conclusion at 70 was that the C exception does not expressly set out how OFWAT is to respond to a representation. Inevitably, how OFWAT can respond is a matter of implication. So he didn't find the answer to lie in the wording of the C exception itself at all. In our submission with respect to the judge, that undersells what is in there. His reasoning at 67 through to 69 as to on the basis of being a but-for analysis doesn't follow. It particularly doesn't follow when you understand that on the basis of has to be read together with the phrase at the end, directed at self-induced frustration. We say the text is a very clear pointer in a scheme obviously not designed or drafted by lawyers to point to some kind of fault analysis. And his analysis doesn't address the significance of the word exclusion and exception being directed to it. In other words, that the exception is an exception to the rule of no exclusions and therefore an exclusion. And nor does he address how all of this is to work with the performance measure. In other words, how are you to read this in circumstances where the end goal is plainly to decide which data does or does not go into the relevant performance measure. And we say, once you know that there is a performance measure, and once you know that you're in the field of exclusions, the natural and obvious way to read it, as with every other PC, is as to a decision as to whether or not to include the data. So that's where we get to in our case of language. There's not much between us and the judge. And my learned friend's case, and perhaps that's where I should pick up after lunch, is that effectively, the language is clear and unambiguous on its face, and the language of the provision is dispositive, which is, of course, not an argument the judge has made, and like so many of my learned friends' other points, it's not a point accompanied by a respondent's notice. I make no procedural complaints about that. I'm perfectly able to deal with the points, but it will be material to note how very differently OFWAT seeks to defend this result to the actual reasoning of the judge.
Thank you very much. We'll resume at 2 o'clock.